Okay, hi everyone. Thank you so much for joining us. Today we're going to talk about the path of a case and kind of from what happens before we even get to a shelter hearing all the way through judicial reviews, case plans, right up until termination of parental rights. So today we have Rachel Hopkins. She is a circuit director for the Guardian Ad Litem office in the 7th Judicial Circuit. She has 11 years in dependency, and she's held all the positions at the Guardian Ad Litem office, managing attorney, senior attorney, and Guardian Ad Litem volunteer. She achieved the designation of Certified Public Manager in 2025, and she serves on the Legal Needs of Children Committee. Next up, we have Candace Brascomb. She is Deputy General Counsel for the Guardian Ad Litem office. She also supports statewide legal training and professional development initiatives for agency attorneys and works closely with risk management and outside general counsel on litigation matters. She has over 15 years experience in government leadership and litigation. And then we have Amber Speers. She is a judicial staff attorney in Duval County, Florida. She has more than a decade experience in dependency, and she has dedicated her career for advocating for children in the dependency system. Her prior role to a judicial staff attorney was a senior attorney with the Guardian Ad Litem office and then with Children Legal Services. And she also serves on the Legal Needs Committee. And I am Brittany Rutan. I'm Regional Legal Counsel with the Guardian Ad Litem office. I have 15 years of experience in dependency. I'm board certified in juvenile law, and this is my 6th and final year on the Legal Needs of Children Committee. So with that, we'll get started. Like I said, we're going to start with investigation, then go to arraignment through disposition. Candace is going to talk to us about case plans and case plan goals, and then Amber will speak with us about judicial reviews. So we have this handy dandy chart, is very helpful when you just want a screenshot of what's going on, what are the next steps. I believe we also put it in the chat, so that is available to you. We're going to talk about the first one here today, and then the second flow chart kind of walks you through what happens. Are we going reunification? Are we doing termination of parental rights? But today's presentation will focus on the first one. So what is dependency court? When a child has been abused, abandoned, or neglected, then the Florida's child welfare system steps in to help protect the child. And that includes various agencies to provide services to ensure that the child is safe and that we can safely reunify the child with the family. The dependency court is the system that governs that, and these court proceedings are the dependency proceedings. Now, dependency hearings are open to the public. However, the court has the ability to exclude someone or everyone, depending on whether or not that public interest or the welfare of the child is best served with that. However, termination of parental rights proceedings are closed to the public. And then, of course, Chapter 39 of Florida statutes is what governs all of our dependency cases, and that's what we'll be referencing throughout this presentation. So who gets to be a part of the dependency proceedings? Parties are going to be their parents, the petitioner, the department, the guardian ad litem, and the child. Typically, the petitioner is going to be the department or the guardian ad litem, but sometimes we do get private petitions where you have a parent that is filing a dependency action or a grandparent relative that's filing an action. So in that circumstance, they would be the petitioner. And so participants are only given notice of hearings and an opportunity to be heard. And those individuals are going to be the caregiver of the child, your foster parents, identified prospective parents, and we're going to talk about paternity here in a little bit. But whoever the legal father is, that's going to be the party. But if, the mother has identified a biological father, that individual would be a participant to the hearing. And then any other person whose participation may be in the best interest of a child, and that's a determination for the court to make. So while you might have other individuals that are trying to become a part of the dependency proceeding, that is a decision for the court to make. Okay, so here's a quick overview of what we're going to talk about. So starting with the removal of the child from the home, going to the shelter hearing, Then we get to an arraignment and your dependency hearing or trial, ordering them to do a case plan, what's going to go in that case plan, and our judicial review hearings and permanency hearings. Um, excuse me. So that's kind of where we're going to lead through today. So first up is going to be the removal of the child and starting an investigation. So it all starts with an abuse report to the hotline. And then after that, the individual on the phone is going to make a determination as to whether or not this is going to be accepted or denied. If it gets accepted, then it gets assigned a child protective investigator based on the severity of the allegations, if it's going to be immediate response or the 24-hour response, and then they are going to do their investigation, and then based on their investigation, it may lead to the judicial intervention. So after you have the call to the hotline, the child protective investigator has 60 days to complete their investigation. They'll make a determination if the child has been abused, abandoned, or neglected. If they make the decision to take the child into custody, then they're going to start looking at backgrounds and working on a home study. Where can this child go? Obviously, we want to try to keep the child in the most family-like setting. We want to have the child with someone that they know, if at all possible. So they will do backgrounds and home studies on them to see if any of that is possible. And then they will make a temporary placement pending the hearing. And then they'll talk with the Children's Legal Services, with the Department of Children and Families, and they will get the petition drafted and do the notice of hearing. Now, before we get to the shelter hearing, let's talk about safety plans real quick. So safety plans are defined as a plan to create and control present or impending danger using the least intrusive means appropriate. So during the course of the investigation, the child protective investigator is going to implement a safety plan to determine, okay, can we implement services? Can we do something to not result in a removal of the child from the home? If there is present or impending danger, then they have to implement that safety plan. If there is present danger, the child protective investigator has to complete the safety plan before they leave the home or the location of the child. If it's impending danger, they have to create the safety plan as soon as necessary in order to protect the child. So if there's present, it has to be done immediately. We're not going to leave a child in that situation. We're going to act first. Now, the safety plan has to be specific, sufficient, feasible, and sustainable in response to the realities of the present or impending danger. And this is something that's important when I'm sure in Dependency, when you're reviewing things, you see safety plans that are coming in that happen before you get to the shelter hearing. And one of the main things is you want to make sure that it is not based on promises, not a parent promising that they're not going to do something. It has to be something that they're able to achieve. And it has to be a parent that has the capacity to be able to do that. If a parent doesn't have the capacity to comply with the plan, then it's not appropriate for a safety plan, and that would result in a removal. All right, so we've gotten to our shelter hearing. This has to be within 24 hours of removal from the home. The standard of proof is probable cause, and all relevant material evidence is allowed. So it's a very low burden. Everything comes in, leading up to it. Any information with regards to if there was an arrest, the police report, what collateral contacts are saying with regards to the history, if there's prior dependency cases, all of that is information that can be brought before the court. So at the hearing, the petitioner has to prove that the child has been abused, abandoned, or neglected, that the parent has materially violated a condition imposed by a court order, or there's no one available. So perhaps the mother has been arrested and the father is unknown. That would result in a shelter. Or sometimes we see lockout situations where you have children in delinquency cases, they're ready to be released, but the parents are refusing to pick up the child. So at the shelter hearing, there's several things that the court has to do. The first is to appoint the guardian ad litem office. The second is to inquire as to who are the parties. And this is what we were talking about before. The court will do a paternity inquiry of the mother and any possible fathers that are present to determine, was she married at the time of the child's birth? Was she living with a man at the time that the child was conceived? Has anyone held themselves out to be the father? Is there a court order indicating that someone is the father of the child? And so that will help determine as to who the legal father is. We see a lot where a parent is married and that is the legal father, and then we have, another man that's listed on the birth certificate, and that's where things get complicated. But unless there's a disestablishment of paternity that is done, the the man in which the mother is married is the legal father to that child, and that will be the party to the case. The court will inquire of the parents if there's any potential relative placements or non-relative, anyone that is available to take the child to prevent the child having to be in foster care. If they're out of state, then ICPC, Interstate Compact for the Placement of Children, that applies, and that is a very lengthy process of like 3 to 6 months in order to get an answer depending on the state. So if there's a local option, even if it's in the interim pending a home study from an individual out of state, that's always best case scenario. The court will inquire regarding getting the parents' consents to access the child's medical and educational records, find whether or not the department has made reasonable efforts to prevent the removal, and we'll talk about that in a second, and then inform the parents that they will likely get a case plan, and if they fail to comply with that case plan, then their rights may be terminated. So at the shelter hearing, there's lots of topics that are going to be discussed. The first of which is placement. We'll talk about the priority of placements in a little bit. But where is the child going to be? What information do we have up against for any non-relative or relative placements? Is it appropriate and safe? What visitation is going to be, not only for the parents, but also for the siblings. If the children are not going to be placed together, making sure that there is something in the court order to ensure that they're having that frequent contact, as well as what are the parameters around the parents' visitation in order to ensure that the child is safe. And in line with that is the Keeping Children Safe Act, and that applies where child sexual abuse has been alleged or occurred, and that triggers a presumption of detriment for contact with that parent. So that is something that will need to be explored if that isn't a component of your case. Child support, whether or not a special needs attorney is appropriate, and there are 5 circumstances in which a special needs attorney would be appointed automatically for a child. If there's any counseling or services needed for the parents or the child, looking at a shelter petition, you can see, okay, if it's sexual abuse, you're going to be asking for sexual abuse counseling. If it's, if there's a death, grief counseling, if the child is on medications or developmentally delayed, making sure we're getting the appropriate evaluations and therapies for the child are all things that we want to make sure are explored by the department. As well as psychotropic medication. We just did a training on that, and that goes through all of the steps that the department and the court has to make in order to authorize a child to be on medication. But at the shelter hearing, the department will come forward, and if the child is already on medication, they will be seeking approval to continue that until the arraignment hearing. And then if there's any other issues that are specific to the case that need to be brought up. Okay, so reasonable efforts. The order has to indicate that the department has made reasonable efforts to prevent the need for removal, and that finding is automatically made in these 4 specific scenarios. If the first contact is with the department, with the family, is during an emergency, if the home situation is substantial and immediate danger of the child's physical, mental, or emotional health, if the child cannot safely remain home because there's no preventative services that can ensure the child's safety, or the parent is alleged to have committed any of the acts listed in an expedited termination of parental rights. So if you have egregious abuse, if there's a death, if there's something that is immediate and there are no services or anything that can prevent the child from being removed, then there's automatically a finding of reasonable efforts because we're acting to ensure that the child is safe. We're not going to leave a child in a home that is unsafe in order to attempt to put services when that won't fix the situation. And then 39402 10 also talks a little bit about this with regards to if there are services that could have prevented or eliminate the need for removal, the court has to make specific findings. If they're not um, available for that, there has to be a description as to why. And if they haven't made an effort to prevent or eliminate the need for removal, the court has to order the department to provide the appropriate services to ensure the child's safety when the services are necessary. And then here's the priority of placements we were talking about. This is the order in which is preferred for placement of a child. So first is obviously going to be with a non-offending parent. If you have allegations about a mother and a dad is out of the home, living his own life over here, and there's no concerns with him, then obviously placement with the non-offending parent would be appropriate and the least intrusive for the child. A relative caregiver, if there's an adoptive parent of a child's sibling, um, if that is information that you're aware about at the start of the case. Fictive kin with a close relationship or non-relative that doesn't have a relationship, foster care, and group home. So not only in shelter, but throughout the life of the case, these are going to be the priority of placements that we're going to look to try to get a child out of licensed foster care and see if there's a more appropriate setting that is more family-like for the child. And with that, I'm going to turn it over to Rachel.
Good morning. So following the shelter hearing, a dependency petition will be filed. The petition will contain similar allegations to the shelter petition, but may contain additional information that has been discovered through continuing investigation since the shelter. The court will hold an arraignment no later than 28 days after the shelter hearing for the parent to enter a plea to the dependency petition. So the parent has to be served with the petition and a summons at least 72 hours before the hearing. However, if the parent appears at the arraignment either in person or virtually, that obviates the need of serving that parent and the hearing will proceed. If the parent is not served and does not appear, then the hearing will be continued for service. Next slide. So if the parent enters an admission or a consent to the petition, the court must make a finding that the plea is made knowingly, voluntarily, and intelligently. The court typically conducts a colloquy prior to making that finding, and the court will then schedule a disposition hearing within 15 days. If the parent enters a denial, the court must set an adjudicatory hearing within 30 days. If the parent is served in time for the arraignment and they fail to appear, their failure to appear constitutes a consent to the petition, and the court will schedule a disposition hearing within 15 days. And a written answer is not required to the dependency petition. The plea alone is sufficient. So if the parent enters a denial and you proceed to an adjudicatory hearing, adjudicatory hearings on a dependency petition is commonly referred to as a dependency trial. The standard of proof is the preponderance of the evidence, and the rules of evidence do apply in the adjudicatory hearing. So backing up to the arraignment, if the parent is ordered to appear for the adjudicatory hearing and they fail to appear, similarly to if they were served in time for the arraignment and if they fail to appear, their failure to appear at the dependency trial constitutes a consent, and the court can move forward and schedule a disposition. So at the adjudicatory hearing, each party has the right to call and cross-examine witnesses. The child, parent, or caregiver may be examined separately and apart from each other. This is mostly going to be done for the child, and depending on the age of the child and the allegations, you may be looking at asking for an in-camera examination, or if the child is going to testify in the courtroom, having the parents removed to a different area where they can listen by Zoom or by phone while the child testifies. If at the conclusion of the trial, the court finds that the allegations in the petition have been proven, the court will grant the petition. If the court finds that the child can safely remain in the home of a parent or can safely be returned to the home of a parent, and the court finds that no other action other than supervision in the parent's home is required, the court can withhold adjudication and just order that supervision. If the child is going to remain in out-of-home care, then the court must adjudicate the child dependent. During the trial, at the conclusion of the petitioner's case, any party may motion for a judgment of dismissal. If the court finds that the petitioner has not provided sufficient evidence to prove the allegations, the court must enter an order dismissing the case. The court can also find that some but not all of the allegations have been sustained. And the court could also conversely wait until the conclusion of the trial until the parents have put on their own evidence to make a determination, and at that point determine that the allegations were not proven and dismiss the case. So if the case is not dismissed and you are proceeding to a disposition hearing, again, if that parent enters a consent or an admission, the disposition will be within 15 days. If the case proceeded to a dependency trial, then the court has to hold the disposition within 30 days of the last day of the dependency trial. And as part of the disposition hearing, the court is going to review certain things, including the family functioning assessment, which is filed by the department. The family functioning assessment, or is commonly referred to as the FFA, is used to identify and address child safety risk and protective capacities. We refer to this as a living document. While that initial FFA is going to be filed for the disposition hearing, the department will file ongoing FFAs throughout the case. They are a great resource of family history. However, the court can waive the filing of the FFA for the disposition hearing if the court finds that all of the family and child information required by statute to be in the FFA is available in other documents already filed with the court. The court will also consider the recommendations of the guardian ad litem and any other relevant and material evidence, including other written or oral reports, may be relied upon to the extent of their probative value, even though not competent in an adjudicatory hearing. And you'll see similar language used in other parts of the statute, such as for judicial reviews, hearings related to the Keeping Children Safe Act, or Chapter 39 injunctions. And this is related to the strong public policy that protecting vulnerable children is of paramount concern. And the judges making decision on child safety need to be aware of all risk factors when making decisions. So also as part of the disposition hearing, the court has the power to enter certain orders, such as requiring any person with custody or seeking custody of a child to submit to a mental health or a substance abuse disorder assessment or evaluation for good cause shown. There are also several findings the court is required to make, including where the child is going to be placed, any condition of placement or visitation, whether the child could be returned with an in-home safety plan. And if the court finds that an in-home safety plan would allow the child to safely remain at home, or that the conditions for return have been met and a child could be returned home with an in-home safety plan, then the court will make a specific finding of that fact and that the child's safety, well-being, and physical, mental, and emotional health will not be endangered. And Brittany defined safety plans for you earlier, but essentially a safety plan is a written document that identifies specific actions that need to be taken and who is responsible for those actions in order to keep a child safe in home with their parent. And the department, the guardian ad litem, and the parents are involved in developing an in-home safety plan in an open case. As part of the disposition, the court must also find whether the case plan that has been filed with the court is appropriate to address any safety concerns for the child, or whether or not they're going to require certain amendments to be made to the case plan and have an updated case plan filed. And there are additional findings the court is required to make under 39.5211E. There are also, the court addresses the visitation issues at disposition hearings, specifically looking at sibling visitation or parent visitation. So within the statute, parents have to receive visitation at least one time per month. It is typically much more frequent than that. And sibling visitation at least one time per week, showing the importance of maintaining those sibling bonds if siblings are not placed in the same home. In dependency, grandparents do have the right to reasonable visitation with their grandchildren, and this covers step grandparents as well. There are some caveats, though. The child has to have been adjudicated dependent. The court has to have not found that it's not in the child's best interest for that visitation to occur, or that the visitation would interfere with the case plan goals. So if there is a parent who is, or grandparent who is not supportive of a parent and is very vocal about not liking one of the parents in the case, that might interfere if the goal is reunification. And also the grandparent must not have essentially any disqualifiers that would fall under the Keeping Children Safe Act, such as allegations of sexual abuse against the child. And now I will turn it over to Candace.
Great. Thank you, and good afternoon. Rachel touched on a little bit case plans. So now we're going to talk about case plans. It's one of the central tools used in dependency cases. A case plan outlines the services and treatments that will be offered to the parents and the child, and it also identifies the outcome measures that must be met to achieve the child's permanency goal. So, in other words, if permanency is the destination, the case plan is ideally the roadmap for how we get there. Under Section 396011 sub 1, the department is required to prepare a draft case plan for every child who is receiving services in a dependency case. The case plan is going to establish what the parents need to do to address the issues that led to the child's removal or dependency finding. These are usually things like substance abuse treatment or parenting classes, mental health counseling, or domestic violence intervention. So another important thing to know is that the case plan has a compliance period, which cannot exceed 12 months. The compliance period runs from the date of the shelter or the date the case plan is accepted by the court, whichever happens first. The statute also notes that the compliance period should actually be shorter than 12 months if appropriate. And if you think about that, that makes sense. That timeline is important because the dependency cases are designed to ideally move relatively quickly towards permanency for that child. Also worth noting is that the case plan tasks and services are not necessarily fixed forever. They can be modified later if circumstances change. And finally, the statute requires that the child participate in the development of a case plan if that's appropriate. And so the idea of this recognizes that children, especially older children, can often have valuable input about services, placement stability, and visitation. So, one of the fundamental ideas behind case planning is family engagement. Parents are entitled to participate in developing the case plan. This is reflected in Section 39.6011, sub 1D, which provides that parents must be given the opportunity to participate in case plan development. That said, parents don't always choose to participate, right? So if they do refuse to participate, the department is still permitted to move forward and develop the case plan, but the department must document the reasons for the parent's lack of participation. Another situation that comes up fairly frequently is incarcerated parents. So Florida law specifically addresses this in Section 396021. When a parent is incarcerated, the department may reach out to the correctional facility that is housing them to determine how that parent can participate in case planning and what services might be available within that facility. So, for example, that facility might offer substance abuse programs or parenting classes or counseling. The department must also provide the incarcerated parent with a copy of each case plan. And to the extent possible, the case plan should take into account the services that are actually available within that facility. If the facility cannot provide a list of services, the department is required to note that in the case plan. So the key takeaway here is that incarceration does not automatically remove a parent from the case planning process. in that law still requires reasonable efforts to involve the parent when reunification remains a goal. So before the case plan is finalized and submitted to the court, the department typically holds what is known as a case plan conference. The purpose of the conference is to bring together the key participants in the case and discuss the proposed case plan before it is actually filed with the court. So during this meeting, the participants, review several important issues. First, they're going to review safety concerns and the reasons that the child came into care to begin with. Second, they're going to identify behavioral changes that need to occur for the parent or parents to safely care for the child. Third, they determine the services that will help the parent achieve those goals. And like we mentioned before, that could be therapy, that could be treatment programs, parent education, etc. And finally, the conference gives parents and other participants the opportunity to provide input and ask questions before the plan is finalized. So, although the statute doesn't specifically prescribe the exact format for these conferences, the requirement that the department prepare a case plan and allow for the participation of parents and children is found in Section 39606, or 6011 Florida statutes. So who participates in these case plan conferences? So it can include a variety of participants. Now, typically those meetings are coordinated by a case manager, but the participants may include parents, the case manager, as I mentioned, guardian ad litem, the child, if appropriate, caregivers, sometimes attorneys. Children may participate when it is developmentally appropriate. That is also in Section 39.6011. These conferences are often where the practical discussions occur about what services are actually available and what tasks are realistic within the compliance period. So this is one place where dependency cases can operate differently than other types of law. Dependency is very service driven, and the case plan conference is often the first opportunity to discuss the services that will be offered and the expectations that will be placed on the parents. Once a case plan is in place, it doesn't necessarily stay the same forever. The case plan can be amended at any time. However, there is something really important to keep in mind here. Case plans cannot be extended. If we come to the end of a compliance period, the department cannot simply extend the existing case plan. Instead, a new or amended case plan must be developed. Now, amendments to case plans can occur for several reasons. For example, the department may need to change the permanency goal, add or remove tasks for the parents, provide additional services for the child, or update the child's records. Another concept that sometimes appears in amended case plans is concurrent planning. Concurrent planning means that while reunification is still being pursued, the department is also exploring another permanency option, such as adoption, at the same time. So speaking of that, let's talk a little bit about permanency goals. The case plan must include permanency goals for the child, and permanency goals are established in Section 39621 and are ranked in statute in order of preference. The preferred permanency goal is reunification, meaning the safe return of the child to the parent. If reunification is not possible, the next preferred goal is adoption. After that, options include permanent guardianship, permanent placement with a fixed or willing relative, and finally, another planned permanent living arrangement, often referred to as APLA. These goals represent the long-term placement outcome that the system is working towards for the child. Oh, I should also mention, Florida law prioritizes permanency for the child because it has been shown time and time again that prolonged uncertainty in placement can really be harmful to children. So you will see this continued emphasis on permanency and a quick move towards permanency all throughout statute. So when reunification is not possible, adoption is generally the preferred permanency option. Under the Federal Adoption and Safe Families Act, as well as Florida law, adoption provides the most stable and legal permanent placement for a child. Adoption requires the termination of parental rights, which permanently severs the legal relationship between the biological parents and the child. So once adopted, the child has the same legal relationship with the adoptive parents as as if the child had been born to them. So conversely, we also have permanent guardianship, which is also another permanency option. Permanent guardianship creates a legal relationship between the child and the relative or another approved adult who will assume the responsibility for the child's care and decision making. However, unlike adoption, termination of parental rights is not required for permanent guardianship. The parents may still retain certain rights and responsibilities, such as the right to consent to the child's adoption and the obligation to provide financial support. So you can see that kind of broken down here. You can find the statutory definition for permanent guardianship in section 39.01 sub 56, and the procedures governing permanent guardianship are in 39.6221. Another permanency option is permanent placement with a fit and willing relative. In this type of placement, the child lives permanently with the child who is able and willing to care for them, but the parent-child relationship is not terminated. So because parental rights remain intact, the child still has the right to inherit from the biological parents, and the biological parents still retain responsibilities such as financial support. One difference from this permanency option, as opposed to permanent guardianship that we mentioned earlier, is that the department and the court still continue to conduct review hearings every 6 months to ensure that the placement remains appropriate. The final permanency option is another planned permanent living arrangement, often referred to as APLA. APLA is typically used for older youth, usually those who are 16 years of age or older, who may wish to remain in foster care until adulthood. Because APLA is considered the least preferred permanency option, the court must make several specific findings before approving it. The court must determine that reunification, adoption, permanent guardianship, and placement with a fit and willing relative are not appropriate. The court must also inquire about the child's desired permanency outcome, evaluate whether the placement is following the reasonable prudent parent standard, and ensure that the child has opportunities to participate in age-appropriate activities. These requirements are designed to ensure that APLA is used only when more permanent options are not available. So to summarize before we move on to judicial reviews, the case plan is the central framework that guides dependency cases. It outlines the services and tasks needed to address the conditions that brought the child into care, and it works together with the permanency goal to move the case toward a stable long-term placement for the child. So understanding how case plans are developed, amended, and implemented is really critical in dependency court. And as you've already heard, dependency cases really focus heavily on services, behavioral change, and family engagement, all of which are built into the case plan process. So now I will go ahead and turn it over to Amber.
Good afternoon. So the next thing is judicial review hearings. And at these hearings, the court will review the status of the child, review compliance with the case plan by the parties. That would be the mother and father. There could be more than one father. The court would be reviewing all the parties to that case. And the compliance levels that they would be looking at would be whether the parent was in non-compliance with the case plan, so the services that they needed to do, whether it was therapy, some sort of evaluation, whether that's mental health, psychological, a psychiatric therapy, sometimes individual therapy of their own, sometimes it could be family therapy with their child or children. And so they're just making sure that they're actually engaged. So it would be non-compliance if they're not doing what they're supposed to, partial compliance if they're on their way to start making some behavior changes, and then substantial compliance that they've made enough changes that the court and the parties could look at reunification. And then we would look at whether or not those case plan tasks and goals would need to be updated based on the parent's compliance. And then the court would enter orders that further that permanency goal that would be recommended and the safety for the children in the dependency system. The very first judicial review that needs to happen is within 90 days after that disposition hearing that Rachel had talked about earlier, or the date of the court hearing when the case plan was approved, whichever comes earlier, or no later than 6 months after the child's removal, so that shelter hearing from the home. The court shall have continuing jurisdiction in accordance with this section and shall review the status of the child at least every 6 months as required by this subsection, or more frequently if the court deems it necessary or desirable. Some of the ways or some of the reasons why the court may need to look at it more frequently than 6 months is maybe there's issues with the child's services, maybe visitation needs to be looked at more frequent. Maybe we, need to move the parents' visits from supervised to unsupervised. It just depends on the situation, but it can be looked at sooner than that 6 months. Next slide. There's 2 types of reports that will be filed with the court for the judicial review hearing. One will be the department's judicial review report, and then there will be a guardian ad litem report. We'll first start talking about the department's report. So there is a 72-hour filing requirement for the department's report, so it needs to be filed with the court 72 hours before the judicial review hearing. The report prepared by the department with recommendations for the child's placement, those permanency goals that we had gone over just right before with Candace. So whether it is maintain and strengthen, reunification, adoption, permanent guardianship, another planned permanent living arrangement. That's where we would be recommending in that hearing, in that report. Whether or not that goal needs to change, stay the same, whether what type of visitation with the parents and siblings is still being recommended, the education of the child or children, medications the child's on, and any services the child is in, case plan compliance of the parents, and then least restrictive means and reasonable efforts of the department. Least restrictive means the court will look at every single hearing to make sure that if the child still remains out of the home, that that's the most appropriate thing, or whether or not we can get the child home while these services are being offered. And then reasonable efforts is talking about what has the department done and to assist the family with getting the child home. So what services have they offered the parents? Are they giving them the updated referrals they need to do those services? And whether the child has their services in place to be able to make that reunification happen. In July of 2020, the rules changed, or the statute changed, and now the judicial review, the department files must now contain a statement from the caregiver concerning the well-being of a child, the impact of any services provided to that child, the working relationship between the parents and caregivers. The court must review whether the parents and caregivers have a productive relationship with meaningful communication and mutual support. The report does not need to be served on parents who have voluntarily surrendered their child for adoption or who have had their parental rights be terminated. But it will need to be served on the caregivers and as well as the guardian ad litem and parents for judicial reviews if their rights have not been terminated. The court may dispense with the attendance of the child at the hearing, but they cannot dispense with the hearing altogether or the presence of other parties to review unless there's a review of hearing is held before a citizen review panel. One of the reasons why a child may not be at the hearing, even though they have a right to be, is it may not be in the child's best interest. Some of those things might be that it's, too emotionally hard for the child's too young, and, it just wouldn't be in the best interest for the child to be there. If the child has reached 13 years of age but is not yet 18 years of age, a statement from the caregiver on the progress the child's made in acquiring independent living skills. Some independent living skills that the court would be looking for is, have they learned how to cook? Do they know how to cut vegetables, cook on a stove? Do they know how to clean? Budgeting? Do they know how to work on a resume? Do they know how to apply for a job? Driving? Those are the things when we're talking about when we talk about independent living skills. Also, copies of all medical, psychological, and educational records that support the terms of the case plan and that have been produced concerning the parents or any caregiver since the last judicial review hearing. Copies of the child's current health, mental health, and educational records as identified in 39.6012. For a child who's reached 13 years of age but is not yet 18 years of age, the adequacy of the child's preparation for adulthood and independent living. For a child who's 15 years of age or older, the court shall determine if appropriate steps are being taken for the child to obtain a driver's license or a learner's driver's license. And so now we get to judicial review hearings for children who are 16 and 17 years old. At each review hearing held under this subsection, the court shall give the child and the guardian ad litem the opportunity to address the court and provide any information relevant to the child's best interests, particularly in relation to independent living transition services. The foster parent or legal custodian may also provide any information relevant to the child's best interest to the court. When we talk about those independent living services, we're talking about, getting them to transition to being an adult and that they're prepared. So when they're 18, they know how to enter the world and be, an adult in society. The court shall hold a judicial review hearing within 90 days after a child's 17th birthday. The court shall issue an order separate from the order on judicial review that the disability of non-age of the child has been removed for any disability that the court finds is in the child's best interest to remove. When we talk about that disability of non-age, it just means that the child's not yet 18 years old. So when the court enters that order of removing that age or non-age of disability, it allows them to enter into contracts such as leases, bank accounts, buying a car. So we move on to 17th birthday judicial reviews. So during these hearings, the department shall include in their report for this first 17th JR that occurs after the child's 17th, written verification the child has their Medicaid card, certified copy of the child's birth certificate, Social Security card, Road to Independence program. When we talk about the Roads to Independence program, we're referring to a program that helps young adults who are in foster care transition to adulthood. So that includes a program that helps with financial assistance once they turn 18. Some of the ways or how they qualify for this program is that they've at least been in foster care for 6 months prior to turning 18, and that they are going to be enrolled in school, college, a vocational training, or a GED program. They have to apply for this program before they're 21. The goal is to get them set up for education, housing, and skills to live independently. Also, whether the child has an open bank account or material attached that shows them how to open an account, information on public assistance, a clear understanding of a plan for housing, expenses, and education once they turn 18, information related to remaining in care after reaching 21 years of age, letter providing dates that the child is in the jurisdiction of the court. And then the next thing would be a letter stating the child is in compliance with financial aid documentation, the child's educational records, child's entire health and mental health records, the process for accessing the child's case file, a statement encouraging the child to attend all judicial review hearings, and information on how to obtain a driver's license or learner's driver's license. Pursuant to 39.013 subsection 8, for any child who remains in the custody of the department, the court shall, within the month which constitutes the beginning of the 6-month period before the child's 18th birthday, hold a hearing to review the progress of the child while in the custody of the department. So we then move on to the Garden ad litem report, which is that second report I said that needed to be filed for the judicial review hearing. This report also has to be filed 72 hours prior to the judicial review hearing. It will have the Garden ad litem recommendations and information to the court about what's going on with the case, to include placement, recommendations of whether that placement should continue or change, compliance with the case plan as well from the Garden ad litem's perspective, how the visitation is going with the parents and the siblings, and what type of visitation should continue. It will also talk about the child's wishes, which is very important, so the court knows what the child wishes. Sometimes the Garden ad litem's recommendation may be different than what the child wishes, but that report will always have the child's wishes. And then also what the recommendation is for the goal for the case, and what they recommend it continuing. The purpose of this report is just to provide more detailed information than Garden ad litem may have time to present at the hearing, and to also emphasize the importance of achieving permanency for the child. And then copies of the department and Garden ad litem report, like we talked about a little bit ago, must be served on all parties whose whereabouts are known and the foster parents or legal custodians. Judicial review hearings are not subject to formal rules of evidence. The court can consider any relevant material evidence submitted to the court, including written and oral reports to the extent of their probative value. So these reports can be relied upon by the court, and it allows hearsay to come in, which ordinarily would not be allowed. Some of those things that we had kind of been talking about, the parental fitness evaluations, psychological evaluations, mental health reports, visitation reports, all of that will contain hearsay. So statements outside of the court, and all of that can come in during a judicial review hearing, because you want the judge or magistrate who's hearing your case to know fully what's going on and what the parents have been doing, what the child's been doing. And so it's really important that those reports come in. And so that's why hearsay is allowed. The courts read these reports in preparation for the judicial review hearing. So any evaluation that's being done, or visitation reports, or school reports, all of that comes into play during the judicial review. And it's important because they all help for the court to make a determination after hearing everything of what really is in the child's best interest for the goal of the case and placement of the child. Now, who hears judicial reviews? So most of the time, a judicial review hearing is presided over by a judge or a magistrate. It just depends on what circuit you're in and how they do it in that circuit. So that is typically who hears judicial review hearings. But sometimes there are citizen review panels that are allowed by the statute, which may conduct hearings to review the status of a child. The court shall select cases appropriate referral to the citizen review panels and may order the attendance of parties at those review panel hearings. However, any party may object to the referral of a case to a citizen review panel. This is not done frequently, but we just want to make sure you guys know that this is an option for these types of hearings. So the next thing would be a permanency hearing. So this is a hearing to determine when the child will achieve the permanency goal or whether modifying the current goal is in the best interest of the child. Time is of the essence for children in dependency cases. So these hearings are really, really important and give strict time frames of when they must happen. Because as Candace was just talking about, children really shouldn't be lingering in the dependency system because it is not in their best interest. So a permanency hearing is required within 12 months of the child's removal. So that is that shelter hearing we were talking about, or within 30 days of a judicial determination that reasonable efforts to reunify are not required, whichever occurs first. And then at least every 12 months for any child who continues to be supervised by the department or waits for adoption. And so court action for judicial reviews and permanency hearings. The court's findings must be clearly stated in the court order. The court must determine during judicial reviews and permanencies hearing whether the current permanency goal for the child is appropriate or should be changed at these hearings. So once again, those goals that we previously were talking about, maintain and strengthen, reunification, adoption, permanent guardianship, another planned permanent living arrangement. When the child will achieve one of those goals, whether the department has made reasonable efforts to finalize the permanency plan currently in effect. So like we previously talked about, those reasonable efforts are making sure that the parents are getting what they need for services and whether the children are getting what they need for services or the caregivers, and whether visitation meets case plan requirements. And so again, when we talk about visitation, it's whether it's supervised visits with the parents or unsupervised visits, and whether those are occurring frequently, and same with sibling visitations. Are those happening frequently? And so the court will make specific findings on each one of these things in the court order. And during the hearing, the court must consider the reasonable preference of a child. So like we talked about previously in the Garden ad litem report, the wishes of the child. What does the child want? And then also the recommendation of the Garden ad litem. What is in the child's best interest? Is it going home? Is it remaining in care? Is it transitioning, out of foster care if that child's nearing the age of 18? There's two different situations where a judicial review does not apply. That would be when minors who have been placed in adoptive homes by a licensed child placing agency, or minors who are refugees who are guided by federal regulations and who are in the care of a social service agency. So these are the only times where the department's involved, but a judicial review is not needed. So there is the Regis Little Act that became effective on July 1st, 2015. It was designed to protect foster children with special needs by ensuring they have a guardian or guardian advocate in place by age 18. This act mandates updated face-to-face case planning for youth with disabilities to prevent them from aging out of the system without support. At the 17-year-old judicial review hearing, a determination by the court that a guardianship is appropriate and there's no least restrictive means available to meet the youth's needs. And if the court determines the youth may need some sort of guardianship, the department shall complete a multidisciplinary evaluation with a full-scale IQ that is not older than 2 years prior and includes a psychosocial evaluation and an educational report. So once it's been determined that a child does need a guardian, the department will then identify one or more individuals who are willing to serve as that guardian. A guardianship may be initiated or filed within 180 days of the child's 17th birthday, which is why that 17th initial report is so important. That hearing is to make sure if this is going on and a child does need a guardian, it could start to be addressed. And then guardianship is a legal proceeding where a guardian is appointed to exercise the legal rights of a person who's been deemed incapacitated. And then a guardian is an individual or an institution who's been appointed to care for the incapacitated person and or their assets by exercising the rights specifically delegated to the guardian.
Right, that's what we have for you today. Does anybody have any questions?
Can I ask one question?
Of course.
Basically, you mentioned the Regis Little Act and the Guardian. Is there anything that you have as far as in determining guardian advocate or plenary guardian or public guardian for a child that is turning 18 soon, going to be a young adult soon? Thank you.
Yeah, I can answer, and then if anybody else wants to chime in. So there's a whole nother training for guardianships, and it is very involved. But part of the process is meeting with MDT, with case management, and the guardian ad litem, attorney ad litem, bringing everyone together and really going over what are the child's needs, what are there any rights that they can retain? Are they able to make financial decisions, placement decisions? Or is this something where, they have a diagnosis that just prohibits them from being able to make any decisions on their own to where they would be safe? And so having that conversation with everyone and kind of determining, obviously, guardian advocate is going to be the least restrictive. It doesn't have all of the requirements that a full limited or plenary guardianship contains with it. So having a guardian advocate, it's a little bit easier and less involved to get, especially if you're on a time crunch, and doesn't require after the establishment that the guardian advocate have an attorney. There are reporting requirements, but it's not as involved. So all of those are considerations to make when determining which would be the most appropriate. And then figuring out the next step is who could serve in that capacity. Maybe we have someone that can't take placement of the child due to their needs or whatever's going on in their life, but they're, wanting to be there for the young adult and to be able to make those decisions. And it is a lifelong commitment. So it's not something that an easy decision and something that should be taken lightly. I don't know if that answers your question, but
It does. And then the only thing, if I may, just kind of like a piggyback type question, just one little small follow-up question. Is that possible?
of course.
Okay. Just if any of that changes, if your answer changes at all for a young adult or for a child or even a young adult, as far as if they're in EFC, placed in an APD home, or a minor child in a APD home that looks like she will be staying there for a while. Hard to say, but as she's 17 and approaching young adulthood, does your answer change at all for an APD child? Thank you.
No, obviously having someone that knows the child would be better. I know it's really difficult finding public guardians to serve in that capacity. But if there is a relative or family friend or even, a non-relative that is aware of them. I have some of my kids are in an APD home and it's the daughter of the APD um, owner, caregiver, essentially. And so they're around the young adults. They're obviously involved with the placement and communicating and aware of all the needs. And so while it's not someone that the child necessarily knows, it is someone that is able to help make those decisions and is best suited versus a public guardian that's just coming in and doesn't have any information. And with regards to the type of placement, for an APD home, what level, it just depends on who I think your guardian is going to be, and what their level of involvement they want to be. And again, it's easier to do the guardian advocate. It's much more involved to do the other one. It's possible. It's not, we have done those, but if you're looking at someone that's not as versed in the area, a guardian advocate might be a little bit easier on them.
Thanks a lot.
You're welcome. Anyone else have questions? I think you're just a couple months out from the test, so.
Brittany, someone had asked in the chat if it was possible to get a copy of the PowerPoint presentation and who they should contact.
Yes. You can get a copy of the PowerPoint. And you can reach out to me, that's fine. I can put my email in the chat. Well, if there's not anything else, thank you guys so much for joining us. We'll stick around just in case anybody has anything else or last thoughts that you want to chat with us about, but we appreciate you attending and good luck on the test.